Hello, my name is John P.L.C. I'm a probate litigator in the West Palm Beach, Florida law office of the P.L.C law firm, PLClawfirm.com. Today is April 8th, 2016, and I'm going to be speaking to you about a probate litigation topic today based on a corrected opinion that was issued by Florida's 4th District Court of Appeal on Wednesday, April 6th. Now, I'm going to tell you why a foreclosure case is important to Florida probate litigation attorneys in a moment. The case that we're discussing is the Maslick case, M as in Mary, A, S as in Sam, L-A-K, Maslick v. Wells Fargo Bank. It was just released on April 6, 2016. A complete copy of the opinion is available at the Palm Beach Appeals Court website, the Florida's 4th District Court of Appeal. Their website is 4DCA, the number 4, DCA, District Court of Appeal.org, and they have a link to their published opinions. It's 3 consolidated appeals. The first one is 4D, 4th District, 14, filed in 2014, -4672. So why is the Maslick case important to Florida probate lawyers who handle trials involving undue influence or will contest or objecting to trusts or trust amendments? And the reason for this is we know that Florida probate lawyers and Florida estate planning attorneys do a very good job of writing wills and trusts, but it's actually the Florida trial attorneys who handle estate disputes who try the cases, and they handle the litigation involving those wills and trusts oftentimes after a person has passed away or has lost competency. So a Florida probate litigator needs to know not only matters of wills and trusts, the Florida Probate Code, the Trust Code, the Guardianship Code, but also matters of evidence, Chapter 90 of the Florida rules, the Florida statutes, and also the Florida Rules of Civil Procedure. Why is this important? In undue influence cases and will contest cases, lawsuits to set aside a will or mom or dad's revocable trust, issues of competency can come up, such as when mom or dad were suffering from dementia or Alzheimer's, and their medical records can come up. So many times you need to get the medical records into evidence at an undue influence trial or a will contest trial in Florida, and you should expect an objection. The objection may be based on hearsay, and you have to get around that objection. And the way to get around that objection for medical records can be through the business records exception to Florida's hearsay rule. Another important reason that you want to read this Maslick case is for financial records. Many times in trust litigation lawsuits in Florida, or guardianship litigation, or post-death probate litigation, we're looking for a money trail. There are questions or allegations about somebody misusing money, whether it's a trustee who has taken money improperly, or a guardian who has misused money, or an executor or a trustee, or someone with a power of attorney who has used money improperly for their own benefit. You have to find the money trail. Many times discovery in these instances will turn to financial discovery, and you need to obtain bank statements, records from financial institutions, brokerage accounts, IRAs, other financial statements, including account opening documents. How do you get those documents into evidence if you want to prove that a trustee or power of attorney has acted badly? And by the same token, the reverse of that is the defense of these Florida litigation, these Florida probate litigation cases. How do you defend your trustee? How do you defend your executor and your power of attorney? At the P.L.C law firm, we not only handle plaintiff-based claims and lawsuits helping beneficiaries and family members, but we also have a very vigorous defense practice helping individual trustees, executors, personal representatives, and those who had a power of attorney. So how do we get those documents in over a hearsay objection? The business records exception to the hearsay rule may be the way to get there. The business records exception to the hearsay rule in Florida is often one that's widely cited, yet not thoroughly understood by trial attorneys. You should read this Maslick case. Why? The 4th DCA overturned a trial court's ruling on an objection. There was an objection in the trial court that a witness testifying, seeking the admission of certain documents, there was an objection to that witness testifying, and there was an objection to the introduction of certain documents as hearsay. The argument by trial counsel at the trial level in making that objection, trying to prevent those financial documents from coming into evidence, including payment history, was that simply the witness was not qualified to either authenticate the documents, or a foundation could not be laid by the proponent of those documents. What does all of this mean? When you have documents that you want to get in at a probate trial, you can ask the other side to stipulate to their admissibility or to their authenticity. If the other side will stipulate, the documents may come into evidence. But what happens if the other side to your trust lawsuit or your probate lawsuit in Florida doesn't stipulate to their authenticity? Well, then you have to have a witness who can introduce those documents. That witness needs to be qualified. That witness needs to have personal knowledge of those documents so they can testify that they have that knowledge, such that their testimony is truthful and helpful to the court. Somebody without knowledge of these documents will not permit the lawyer, the proponent of those documents, to lay a foundation such that the documents may be submitted to the court and admitted into evidence. So the business records exception to the hearsay rule says that if you have a set of business records, they may be admitted upon proper proof. They may be admitted for the truth of the matter asserted, and an objection to that may be overruled if you jump through the right hoops. And if you look at the Maslek case, it cites the Sanchez v. SunTrust case, 179 Southern 3rd, 538. It's a 4th DCA opinion out of Florida from 2015. And it says that the business records exception allows a party to introduce evidence ordinarily considered inadmissible hearsay and there's a four-part test. Now, to achieve this four-part test to get these documents into evidence, you have to lay a foundation. You call your witness, and that witness needs personal knowledge. The problem becomes when you have medical records or financial records from any hospital or medical care or healthcare provider or any financial institution, you may not be able to get the witness who personally prepared those or made those records. If you have somebody who personally prepared the records you're seeking to get into evidence, call them to the stand. They're qualified to testify, and your documents should get in as long as they're relevant. What happens if you don't have that person? Can you still get those documents into evidence? And the answer is yes. And Maslek is a good example of how you walk through that evidentiary minefield. So the lawyer who is the proponent of the documents, who is calling the witness, needs to lay a foundation for the admission of a business record. Now, it is not necessary for the proponent of these documents to call the person who actually prepared those documents. So if you're trying to demonstrate that mom or dad had dementia or Alzheimer's and could not have signed a will or a trust amendment or a trust restatement in Florida on a specific date, you don't need the actual person who made the entries into a medical file or a hospital file. You don't actually need the person who made the entries into a bank account or a financial statement. You can get around that. So you do need a records custodian, somebody who is in charge of taking possession of assembling these documents that you want to get into evidence. So you need a qualified witness with the necessary knowledge to testify how the record was made. If you have a person, even though they didn't personally prepare the medical records or the bank statements that you want to get into your Florida estate trial, if you don't have that person, get somebody who can testify to personal knowledge about how those records were made. Now, if you don't have personal knowledge about how the records were made, right, the proponent of those documents, your trust counsel or your Florida probate litigation attorney or law firm, has to lay a predicate. Before that witness can testify about those documents, you lay a predicate. What's your foundation? What's your evidentiary foundation? And to do this, it would require you that the testifying witness has the information that has been supplied by an individual who does have personal knowledge of the information that's in those medical records or business records or bank statements or brokerage statements or account statements. So, what's the short answer of all of this? If you're involved in an estate lawsuit in Palm Beach or you're involved in a trust lawsuit in Florida, don't assume that you are just going to hand a set of medical records or a neurologist report, or even in the guardianship context, an examining committee member report, or if you're in the middle of a trust lawsuit, that you can just hand account statements, year-end statements, even an accounting to the court, and that those documents get into evidence. You have to lay a foundation, right? The other side could raise an objection to the admissibility of those documents, and you need to know how to get around that. That concludes my comments about this Florida probate litigation topic today.